Your names?
Travis Hawkins.
All right.
Right from the start, the tone of this hearing tells you something important. This case has already reached the point where settlement failed. When a judge opens by asking whether the parties tried to resolve this matter, that's not small talk. Courts strongly prefer disputes to settle before trial. Trials cost time, money, and resources for everyone involved. So when both sides walk in still ready to fight, it signals that neither side is willing to budge. Now here's what makes this moment interesting. The judge is probing whether there was any real negotiation behind the scenes. Were they close to an agreement, or were the parties miles apart the entire time? Because that answer tells the court a lot about what kind of trial this will be. And listen carefully to how quickly the conversation shifts toward procedural issues. That's a huge theme in this case. This isn't just about money or damages. It's about how the case is being handled legally. Procedural mistakes can completely change the outcome of a case. Even if someone feels morally right, courts still require the correct legal steps to be followed. So keep that in mind as we move forward. Because what unfolds in the next few minutes is a masterclass in courtroom procedure. And the judge is about to make it very clear that rules matter. Quick question for you watching this. If two sides can't settle before trial, do you think it usually means one side is being unreasonable? Or that both sides simply see the situation completely differently?
You folks tried to resolve this matter or no? We're just going to go to trial. Pardon?
We attempted this weekend. And we did not come to a resolution.
How close were the parties before we go into this?
Not very close, sir.
Mr. Ellis, you'd agree with that?
Yes, Your Honor. The defendants do not feel that they owe any money.
All right. You sent something to Ms. Loudon. She's right now doing that.
I'm sorry.
She's doing that right now. You did?
I'm doing it right.
Okay. On the Lewis Loudon matter, only because she was here the last time, seemed rather intent on proceeding with the case. And I think it indicated she was going to get an attorney and do some other things. I'm going to we checked the courtroom, see she's not there. Going to try to send an email and to her, and I'll ask your patience. I'm going to do that because of an email that she sent regarding certain medical issues. So it'll be just a minute, but I won't hold you guys very long. Is that okay, Ms. Barton?
Absolutely, Your Honor. Absolutely.
Wow, what happened? She must have had a good holiday.
It's always a pleasure to be.
Yeah, I don't know. That's not. Check her ID. That's not Miss Barton. Okay. On this matter, then, this is the date and time set for trial on the Summoning matter. You ready to proceed?
Yes, Your Honor.
All right. Go ahead.
Your Honor, we have filed a motion to amend our complaint to include a complaint for damages.
This is where the legal complexity begins to ramp up. The plaintiff just revealed something significant. They filed what's called a motion to amend the complaint. In simple terms, that means they want to change the original lawsuit, adding new claims or damages after the case has already begun. Now that might sound harmless, but in the legal world, timing is everything. When a case is close to trial, suddenly changing the complaint can create serious fairness issues. Why? Because the other side may not have had enough time to prepare a defense against the new claims. Imagine studying for one exam, and then right before the test starts, the questions suddenly change. That's essentially the argument the judge is about to evaluate. Courts generally allow amendments to complaints, but only when it doesn't unfairly surprise or disadvantage the other side. And that's exactly what the judge starts investigating here. Did the defendants receive the motion? When was it sent? Did they have enough time to respond? These procedural questions may sound technical, but they can determine whether the new claims are allowed at all. And here's something interesting for viewers. Many court cases are not won purely on facts. They're often decided on procedure. Have you ever heard the phrase, "the case was dismissed on a technicality"? Well, those technicalities are actually legal safeguards designed to ensure fairness.
And I received no response from the defendant.
When was the motion filed?
You can go yesterday.
You guys get a copy?
It was addressed on May 21st.
I don't see a copy of a motion.
I can approach the bench and give a copy.
Do you see it in our thing that it was filed? You do? Yeah.
I have a note on May 20th, plaintiff submitted the motion to. It may have been filed in Saline. When did you reach out to obtain a copy?
Hmm?
Do you need me to reach out to obtain a copy?
I've got one in front of me. When did you guys get a copy of this?
It was dated May 21st, 2024.
Say a few days
A
after
few
that.
days after that,
In what?
just before heading into Memorial Day weekend. That's-
21st?
Yeah, this was dated May 21st.
For what date did you, the postmark? What is that?
Postmark on May 21st right here is the date that it was sent out.
So this is raising issues that they're entitled to answer regarding the security deposit.
Now the judge is drilling down into one of the core issues, the security deposit claim. This is where landlord-tenant law starts to enter the picture. When a landlord keeps a tenant's security deposit, there are usually very strict rules governing how and why that money can be withheld. Most jurisdictions require landlords to provide itemized deductions, written notices, and proper documentation within a specific time period. If those rules aren't followed, courts can sometimes award double damages or penalties to the tenant. But notice what the judge is saying here. He isn't even debating whether the deposit claim is valid yet. Instead, he's focused on procedure. Specifically, whether it's fair to raise this claim at such a late stage of the case. This is a classic courtroom moment where legal strategy meets courtroom rules. If the amendment is allowed, the defendants suddenly have to defend against new allegations. If it's denied, the plaintiff loses a potential claim entirely. So the judge's concern here isn't about the lease terms themselves. It's about whether the legal process is being followed properly. And this raises an interesting question for viewers. Should courts prioritize strict rules of procedure, or should they focus more on reaching the underlying truth of a dispute?
Well, the lease provides that the security.
It doesn't matter what the lease is. I'm talking procedurally. You're raising claims regarding the security deposit at this late stage.
Well, they didn't leave a forwarding address, Your Honor.
Well, but that would precisely my point. They would be in, you haven't alleged that they haven't in this alleged amended complaint. You're just alleging a claim against the security deposit. Because I think as we were here at the last hearing, when we were talking briefly about it, they had indicated that they had provided a forwarding address.
I do not believe that's what they said. I believe
That is exactly what, is that what you said?
Yes, sir.
Your Honor, he,
No, I don't, just answer my question.
yes, yes, sir.
That's exactly what they said.
they did not, Your Honor. They said that he knew where we moved.
Mr. Alice, they said it the last time. I just said it. I asked them to verify that my recollection of what they said is correct. If you have a dispute regarding the facts, fine. But if you're telling me that my recollection is incorrect, you're wrong. They said it. You may disagree, that's fine, but that's an element of any claim against a security deposit, which is precisely what I'm saying. Procedurally, this is a problem.
The tension in this exchange really highlights how courtroom authority works. The judge is pushing back firmly against what he sees as a misunderstanding or possibly a challenge regarding the facts discussed in the previous hearing. And when he says, "If you're telling me that my recollection is incorrect, you're wrong," that's not casual language. That's the judge asserting control over the courtroom record. Judges rely heavily on their recollection of earlier proceedings, especially in cases with multiple hearings. When a party disputes that memory, it can create friction quickly. But the deeper issue here isn't the disagreement itself. It's what that disagreement means for the security deposit claim. The judge is essentially saying that if the defendants did provide a forwarding address, then certain legal requirements regarding the deposit would apply, and those requirements could directly affect whether the landlord had the right to keep the deposit in the first place. This is a key example of how small factual details can carry major legal consequences. A single question, did they provide a forwarding address, could determine whether a financial claim succeeds or fails. Moments like this show why courtroom testimony and precise details matter so much.
It's been pending. They're entitled to answer, first of all, the motion to amend, and this is the procedural route. They're entitled to answer the motion to amend. They haven't been provided. Was this mailed to them?
Yes.
You know, under the court rules, that's not enough time. You can't mail it. Says on the 17th. They don't get it till then, so they're entitled to answer the motion, and then they'd be entitled to answer the complaint if I were to allow them it to proceed. Folks, do you know what you want to do on the motion?
Sure, I'll answer that, sir.
That was an unfair question. Folks, do me a favor. Can you look at that amended complaint for me? And look at paragraph 3. You see it, the numbers that are there? All right. Without telling me why, because I'm not sure what I'm going to do with this yet. Are you disputing the electricity?
It's the electricity.
The electricity amount?
We had no collection of that electricity until the last hearing. So we had no opportunity to even pay Mr. Stemmer back for that.
Okay, but
This section of the hearing starts to reveal the actual financial disputes underneath all the legal procedure. The judge begins walking through the numbers in the amended complaint one by one: electricity, rent, propane, and property damage. And this is a classic courtroom technique. Instead of letting both sides argue broadly, the judge narrows the dispute down into specific line items. Think of it like an audit happening in real time. First, electricity charges. The defendants argue they never had a chance to pay because they didn't know about the charge until late in the process. Second, the $2,400 in rent, which they clearly dispute. Third, the propane charge, which the judge already remembers was a point of disagreement during a prior hearing. And finally, damage claims, which often become one of the most contested issues in landlord-tenant disputes. Why? Because damage is subjective. One side might call it normal wear and tear, while the other calls it property destruction. Courts constantly deal with this gray area, and notice how the judge is carefully confirming what is and isn't disputed. That's not just casual questioning. He's essentially building a roadmap for the upcoming trial. By identifying exactly which issues are contested, the court can focus on the real disagreements instead of wasting time on things both sides already accept.
let me,
I don't have a problem with
pardon?
I have no problem disputing that. That's fine.
You have no problem disputing it, or you
Not
have no problem with that amount? Okay,
every year.
that's fine. That's fine. The $2,400 in rent, are you disputing that?
Yes.
The propane, which we talked about, is obviously in dispute. And as I recall, at the end of the hearing, you're disputing the paint damage. Mr. Ellis, why should I allow this amendment at this late date?
Pardon me, Your Honor?
Why should I allow this amended complaint? Because it raises new claims.
Well, I thought since they did not answer the complaint, we have the absolute right to file an amended complaint without leave of the court.
This moment highlights one of the most common misunderstandings people have when navigating the legal system without formal legal training. The plaintiff argues that because the defendants never filed a written answer to the complaint, they had the absolute right to amend the complaint without the court's permission. On paper, that sounds logical. In many civil cases, parties can amend their complaints early in the process without needing approval. But here's the complication. Landlord-tenant proceedings often operate under different procedural rules, especially in lower courts. In many of these cases, defendants don't file lengthy written responses. Instead, they appear in court and respond orally during the hearing. That's exactly what the judge is pointing out when he says they can answer orally. So from the judge's perspective, even the plaintiff's assumption about having an automatic right to amend may not actually apply in this specific courtroom context. This is a great example of how legal rules aren't always universal. They depend heavily on the type of court and the type of case. And it also shows why legal procedure can become one of the biggest obstacles for people representing themselves. Understanding the law is difficult enough. Understanding the rules of the courtroom itself can be just as challenging.
And they never answered the complaint.
The landlord-tenant proceeding, they can answer orally. Jeez, oh Pete. Know the procedure before we walk in, counsel. Court's going to stand in recess. Sir, did you have a problem hearing?
Yes.
We have equipment that I'll have my staff provide to you so that you can hear the proceedings. Thank you.
All rise.
Yeah.
Yeah.
Okay. All right. Court recalls the case of Samanek versus Okerman and Meltzer. All right. Couple of things here. First thing is the motion filed before the court is, well, I'll say it this way. Usually leave is freely given to amend. This motion, the court could consider to be an untimely filing of the motion to amend the complaint.
Now the judge moves into what lawyers often call the balancing phase of a procedural decision. Courts generally follow a principle that amendments to complaints should be allowed fairly freely. The legal system prefers resolving disputes on their merits rather than blocking claims on technicalities. But timing matters. Here, the judge openly acknowledges that the amendment could be considered untimely because it introduces a new claim, specifically involving the security deposit. And introducing a brand new legal theory right before trial can create serious fairness concerns. However, the judge also recognizes something practical. Even if he refuses to allow the amendment, the dispute over the security deposit likely won't disappear. The defendants could still file a separate lawsuit regarding the same issue. Yeah, and that would simply create more litigation instead of resolving the conflict. So the judge finds himself in what he calls being of two minds. On one hand, procedural fairness. On the other, judicial efficiency. And this moment shows something viewers rarely see. Judges openly explaining their reasoning process in real time. This transparency is actually a critical part of the judicial system. It helps both sides understand why the court makes the decisions it does.
Mainly because it doesn't. It changes the claims and makes a claim against the security deposit. There are certainly disputes, I guess, as to whether or not the Security Deposit Act has been complied with. Now, what that means, since you are operating in pro per, I would just indicate if it hasn't been complied with and wrongfully withheld, you could, under the Security Deposit Act, be entitled to double damages. That is one of the penalties under that act. Not saying that that's the case here, but it is certainly something that is within the realm of possibility. And that, quite frankly, would have been there absent the complaint, absent this motion to amend or the first amended complaint. So there's that. To try to get this matter resolved, and the court really is of two minds. One, given the timing of this and the setting for trial, I almost don't want to permit the amendment of the complaint. However, what would in effect happen is, in this court's mind, litigation regarding it would happen in any event, whether initiated from the defendants or whether initiated from the plaintiff. So my thought is to just get everything here and try to resolve it, however it gets resolved through trial, right? Having said that, the other problem then arises. So let me back up a second. So for you guys, that would be that unless you're objecting to the motion itself, you're then entitled to answer which I would grant the motion. So let me make it easy. All right. So you don't spend your time with that. Then you're entitled to file an answer regarding the complaint. Okay. And basically it's an admit or denial or put forth your position regarding each of the allegations that's in this complaint. Now, having said that, the problem with the complaint as presented to the court is that the complaint would not survive a C8 motion. And that motion, frankly, on the face of the complaint, because it involves the Security Deposit Act, doesn't state the necessary claims regarding the Security Deposit Act. Yeah. And I know I'm talking in legalese and I'm trying not to. Okay. A C8 motion basically says that on the face of the complaint, just looking at the complaint, that the complaint fails to state a claim upon which relief can be granted.
Now the judge introduces a concept that may sound intimidating but is actually a very common legal tool, a C8 motion. In plain language, this is a motion arguing that even if everything written in the complaint were true, it still wouldn't legally justify a court ruling in favor of the plaintiff. In other words, the complaint itself is missing required legal elements. Think of it like building a case on a checklist. Certain facts must be included for the claim to move forward. In security deposit disputes, for example, courts usually require specific allegations, such as how the deposit was withheld, whether proper notices were provided, and whether statutory deadlines were followed. If those required elements are missing, the claim technically fails on its face. But here's an important nuance the judge explains. Failure to state a claim doesn't always mean immediate dismissal. Instead, courts often allow the plaintiff to amend the complaint again to fix the missing elements. This approach reflects a broader legal principle. Courts prefer resolving disputes based on evidence rather than shutting cases down purely because of drafting errors. So the judge is essentially saying, your complaint has problems, but I'm giving you a chance to correct them. That's procedural fairness in action.
The remedy for that is not dismissal necessarily of the complaint out of the gate. It is to permit amendment of the complaint. All right. Got it so far? Okay. When a claim is made against the Security Deposit Act, there are certain, as I've indicated, certain requirements. Certain of those requirements must be pled, except to some very specific limitations within that act. All right. So what I'm going to order is this. And folks, if you don't understand anything that I'm saying, just because this is an awkward posture for this case to be in, but just go ahead and ask me and I'll answer it. I'm allowing the complaint to be amended, but I'm directing that plaintiff must file a proper complaint that would, at least on its face, withstand a C8 motion and properly state a claim upon which relief could be granted under the Security Deposit Act. Plaintiff is to do that within 10 days.
At this point, the judge is transitioning from legal analysis into clear courtroom orders, and these orders create a structured timeline for how the case will proceed from here. First, the plaintiff must file a properly revised complaint within 10 days. This new version must clearly state the legal claim under the Security Deposit Act and include all required elements. Then, once the defendants receive that complaint, they will also have 10 days to submit a written response. Notice how the judge specifically requires a written answer this time. Earlier in the case, oral responses may have been acceptable, but because the complaint is being formally amended, the court now wants everything documented. This creates a clean procedural record moving forward. It's also worth noting that the judge is essentially resetting part of the litigation process. Instead of forcing the parties to rush into trial with unresolved procedural issues, he's slowing things down to ensure both sides are fully prepared. This might feel frustrating to the parties involved, but from the court's perspective, it prevents bigger problems later, such as appeals or procedural challenges. In many ways, this is the judge acting as the traffic controller of the legal process, making sure every step happens in the correct order.
Defendant then has, I'm going to require a written answer this time. Defendant to file a written answer to the complaint. Bless you. Within 10 days after receipt. Okay. So I need an amended complaint from the plaintiff. 10 days out. Once you receive it, even if that 10 days hasn't expired, you need to answer within 10 days of receipt. Oh. Then adjourn the non-jury trial to, will that give me enough time? What's today? I didn't count out my days. Today's 28. 10. The 17th. And then we have the 18th.
We do have.
9 a.m. All right. Then I'll adjourn non-jury trial to, well, on the way out the last time, my understanding is there are nuptials that are to be occurring. So,
Yeah, Brian Michelle is next one, and a bachelorette party.
I don't want to know about a bachelorette party, but go ahead. What? So if I set it for June 18th, is that going to interfere with what you have? I mean, outside the stresses of everything.
For the 21st of June. And I have to be in.
I'll have you out by then. What?
I have to be in Indiana. So I'll be traveling,
It's
but
not that far.
yeah.
Well, will you be traveling? Can you do the 18th and then
Yeah, I'll make
still
it.
get, you'll do it? Okay.
Yeah, I'll make it work.
So non-jury trial, June 18th, 9 a.m. Okay. And then we'll proceed at that point, have your witnesses, have your exhibits, have everything available on the 18th. We're just going to try to plow through as much as we can. All right. Any questions from either side?
No, Your Honor.
All right. And Mr. Semenek, did that help you? Okay. So next time when you come in, just ask for it and we'll make sure you get it. Okay. Thank you. All right. That does that. And it
Oh, so what?
till 1 o'clock. All right. So court stands in recess.
As this hearing wraps up, the judge schedules the next major step in the case, a non-jury trial on June 18th at 9 a.m. That means the judge himself, not a jury, will ultimately decide the outcome after hearing the evidence. By the time that trial happens, both sides will need to come fully prepared with their witnesses, documents, and exhibits. The judge makes that clear when he tells them to have everything ready. What we've seen in this hearing wasn't the trial itself. It was the legal groundwork being laid. Procedural disputes about amended complaints, filing deadlines, and legal sufficiency may not seem dramatic at first glance, but they can shape the entire direction of a case. Now both sides have very clear instructions. The plaintiff must fix the complaint. The defendants must respond. Anyhow. And then the court will finally hear the evidence. Cases like this remind us that justice often unfolds step by step, not all at once. Every motion, every ruling, and every deadline plays a role in determining what ultimately happens in court. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.